Good morning. I have 9 o'clock, and this is the Senate Education Committee. Before we get started, I'd like to have the Senator Birdsell say the Pledge of Allegiance. Start over here.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you. I need a motion to go into executive session.
So moved.
So we are in executive session, and the first bill is SB 96. I don't know if you heard Senator Altshuler, but Senator Prentice is not going to be in today. Okay?
Move on to pass.
I have ought to pass on 96. Do I have a second? I'll second it. Discussion. Here we go. Okay, discussion on the Senate Bill 96 relative to mandatory disclosure by school districts employees to parents.
I'd like to note, for the purposes of discussion, that 1,201 people signed in opposition to this, and only 138 signed in support. And the overwhelming number of people who actually showed up to testify were in the overwhelming opposition. In fact, 1, 2, 3, 4, 5. I have 8 people who came and testified in person. And probably, let me turn my page, might be another one too. And we had 1 person come to support. And I've got, and you do too, this stack of supporters. So this is a bill that it seems only the sponsors are interested in. In fact, I don't see all of the sponsors even listed as supporting it, to be honest with you. So this bill, as we heard, jeopardizes health and well-being of LGBTQ students who deserve to be safe at school, deserve to have confidential conversations with a trusted adult. And this bill is incredibly vague as to what teachers or school staff are mandated to reveal to students' families. Are they mandated to watch? Are they mandated to only talk about conversations? Are they mandated to look at, tell parents about observations they've seen in the hall or in the library? Are they mandated to share rumors or things that they've heard about their child? There's nothing specific. It's not specific. And this bill does more harm than it could possibly hope to do good.
Okay, thank you. Any other comments? So I have a motion of ought to pass, and I have a second. And all those in favor of that motion?
Aye.
Aye. This 2-1.
Nay. I'm going to vote aye. You did not call for the nay, so I'm just going to say it. I vote nay.
Yes, thank you.
Thank you.
I'll take it out. We have SB 98, establishing a study committee to study the issue of school bullying. Yeah,
210.
I'm sorry, they're in the wrong thing, they're 210. Okay, I'm sorry, the SB 210, establishing a study committee to study the issue of school bullying. Do I have a motion? To pass, do I have a second?
Second.
The second, discussion.
The only thing I will say is, I don't know if it's different, but I know even before I became a state rep, there was a study committee to study bullying back in
It was in it was in,
2008, 2009 timeframe.
actually might have been a little bit earlier, and it was initiated by former Representative Donna Schlockman.
Yep.
Yeah, so it was in the early aughts or mid aughts.
So I
so-
do hope, I know bullying is a major issue, and I know it still goes on, so I hope this does a better job of finding out the cause and trying to prevent it.
Do we know what happened with the other bill?
It passed. There was a committee. There were initiatives that came out of it, but again, it's coming up on 20 years old, so
Okay,
definitely worthy of a second look.
so we need to take another look at it.
Yeah,
Okay,
because there are other things that have come out of the internet, face, all of that has.
Yeah, this is pre-Instagram, pre-Snapchat, pre
Yeah.
what once was Twitter,
so do
pre
we
all
have
of that.
further discussion on this bill? Any other thoughts? No? Okay. So I have an ought to pass and I have a second. All those in favor?
I
Yes, 3-0.
Do you want consent?
move consent.
Move to consent?
Second.
And who wants to take it out in case it happens?
I'll take
Would
it
all
out.
you take it
I'll
out?
take it out.
Daryl,
Okay.
he's not here.
Okay, let's get that. Now we have SB 211. Relative to biological sex in student athletes.
What number?
211.
11, thank you.
I move on to pass.
And I'll second that. Discussion.
Again, Madam Chair, 834 people signed in opposition to this, and only 27 support this. This bill is not something that the state of New Hampshire supports. And we heard testimony from Pasha Roberts, who sat right there and gave us a very, very thorough explanation of how he, as a human being, would not fall into the categories outlined in this bill. You cannot legislate people's beings out of the world. We cannot say you don't exist under the law anymore. It's not, you can't do that. They're still here. I mean, it's putting a blinder on going, I don't see anything. We are not monkeys with see nothing, hear nothing, say nothing. We are human beings that need to acknowledge each other's humanity and recognize that what our personal experience may be is not reflective of everybody's experience. And we had people sitting right there at that table telling us, here is my biological experience. Here is what is happening in my body, and it doesn't fit into your categories. So then what? So then what? Where do they fall? What do they do? How do we categorize them? This is a bill that seeks to discriminate, and it seeks to discriminate against a very small, like infinitesimally small group of people in our communities. And if we choose to continue to discriminate against very small groups of communities, you are setting the stage to discriminate against another group and another group and another group. And we know how the poem ends. When there's no one left to stand for you, you go down. So this is not what we do in America. We do not look for people to marginalize. In fact, in 2018, we did exactly the opposite. We were at our best in 2018. This is not our best.
Okay. On the other hand, Senator Altshuler, allowing biological males in women's sports really makes it very difficult for women to achieve their best potential because they're competing against a person who is much stronger, faster than what they are. So I think that it will be discrimination against the women in sports.
And I also
That was
feel
not
that
proved.
it's a violation, as far as I'm concerned, of Title IX. Title IX was passed specifically to help women in sports, and they are trans women are outperforming because they have more muscle, more testosterone. So they are eliminating women's capabilities of their awards, their Title IX. So I'm absolutely, and never mind the fact that there have been cases of women being hurt in volleyball, in basketball, with trans women playing. So I am fully on board with this piece of legislation.
Further discussion?
Madam Chair, thank you, Senator Birdsell. I hope you had an opportunity to read the hearing report,
I did.
but so none of what you have just expressed was in the hearing. We have 5 transgender children who want to play sports, and 5, and this bill is in court. Like, we've already gone around this, so it's already enjoined in court. What is the purpose of doing this again, other than, repeating the same mistake? It's already in court. Somehow there's some magical thinking that if we just do it again, the courts aren't going to notice. It's going to go to court again. Maybe thought we leave this alone and let the courts continue their jobs since we've already done this once before. Secondarily, I would just like to remind the committee, transgender women are women, transgender girls are girls. Period.
Okay.
So, so Title IX protects women's sports and access to sports and educational opportunities for women and girls. So transgender girls are girls. Transgender women are women. We are talking about K through 12. We are not talking about college. We are talking about K through 12. And we are talking specifically about 5 kids. That's it. 5 kids. And right now, we actually heard testimony from people who made it their mission to go. Love that we passed the bullying committee, because we actually have video and testimony from people who witnessed some of our people who came here going to bully one of these children at their game and bringing crowds with them. So we know that this bill is rooted in a hatred that is unbefitting of this legislature. Unbefitting.
Point of order, that this piece of legislation is not made out of hatred. And I take offense to that.
Okay.
So I think that what I
Offense
said-
duly noted. I would suggest maybe watching the presentation of the prime sponsor before taking offense, since some of the language that came out of that presentation was pretty shocking.
Again, point of order, that this was not made out of hatred.
I think we have discussed this sufficiently. Senator Altshuler, I don't think you're gonna have anyone changing their mind at this point. So I would like to, I have an OTP and I have a second, and I'd like to have a vote on this bill. Those in favor of keeping biological males out of the women's sports, say aye.
Aye.
Aye. And those who think they should be part of it, says no.
No.
Nay. So it's 2-1. Okay. Do you want to take it out? Or should I take it out?
I can't take it out, but
I can take it out. Okay, board will take it out. That finishes the 3 Senate bills that we had in education. And I'd like to have a motion to come out of executive session.
so moved.
Second, all those in favor?
Aye.
We're out of executive session, and at 10:30, we will meet again in here to deal with a couple of House bills that we have received. Thank you, Senator Bergdahl. You're welcome. Good morning. I have 10:30. I will open up the public hearing on a couple of House bills that we have. Welcome, everyone. Do we have Caitlin Katab, representative? You'll introduce House Bill 76.
Thank you, Madam Chairwoman and Senate Education members. For the record, my name is Representative Caitlin Kutab, and I'm here to introduce House Bill 76. This bill simply requires that special education complaints, that there be a tracking system available so that parents can see summaries of the complaints. And already redacted complaints tend to be updated to the website. It's just there's much delay before the time that they can actually be seen. And there's some information which isn't often included in there, including particularly the law firm representing the school district. And we would just like to be able to have this information available. I put this in at the request of several parents and some advocates for special ed. They're just wanting more transparency and seeing, are there certain districts that are having particular areas of concern more often than others? And is there a particular law firm that tends to be representing, certain school districts that are having these problems? They're just looking for patterns and wanting to have some transparency. And I do want to make clear that this is not going to have any privacy issues. It's strictly in here that any personally identifiable information will be redacted in accordance with state and federal privacy laws. I'm happy to take any questions.
Thank you. Questions from the committee members? Senator Altshuler.
Thank you, Madam Chair. Thank you for taking my question. So I'm curious about how the summary of allegations is formulated without having identifiable information, particularly, if there's an incident, then how do you maintain the privacy of that student?
Thank you. That's a wonderful question. So depending on the size of the school district, oftentimes it's a judgment call of how much information will have to be redacted out. And it's really usually situational. And if it's, a huge district, you may not know. If it was something that kind of had a lot of visibility, then more information may have to be redacted out. And that's why we are saying we do want to be compliant with the information. And I do think, it is going to be a situational thing where they're going to have to decide which pieces could potentially lead to somebody being able to identify who the student is. Unfortunately, I don't think there's a one size fits all to that approach, because I do think it is really going to vary greatly depending on the size of the school district.
May I follow up?
Follow up?
So if a parent who has filed a complaint, right, and many of the schools in my Senate district are very small rural schools, and we're not alone in the state of New Hampshire. There are more rural schools than not, and if this parent does not want that information shared because they know the nature of the, beyond that there was a complaint, which is public information, but they don't, the date that the complaint was filed, the summary of the allegations, that would be identifying, considering how small their community is. How are they able to pull that information back to protect the privacy of their child and family if they are not wanting? I know there are some people who want to use their children's experience as a way to bring awareness to what they feel is an injustice or a pattern like you've identified, but there are other families for whom that is anathema to the way they move in the world, and so they don't want that.
Thank you for the question. So I think in a case like that, where it was a small school district, it may be a case where where the name of the school district may have to be redacted out, and perhaps it could just be identified by saying, a certain geographical location. It does have right in here that they shall redact all personally identifiable information, if including the name of the school district would be identifying the student, then that piece would have to be redacted out.
Let's follow up.
Follow up?
So, we'd be open to, a friendly amendment that would put that as part of the policy, because right now that's, anecdotal, and it doesn't really give, the department the authority to move outside the bounds of lines 24 to 29. So including a caveat for parental objections, or outlining what would be identified, because this doesn't say, well, if you're under, that we have had bills before that say if your school district has, under 500 people in the district, it's pretty identifiable.
Thank you for the question. So it doesn't say that it shall include these things. It just says that it shall be limited to those, meaning that we're not going to include more than that information. And we are saying that we're not going to include anything that is personally identifiable. All of the complaints do eventually get posted, so we don't have an opt-out option right now. The additional pieces that we'd be including would be the name of the law firm is often not included in there. And then a date is often also not included in there. So those would be kind of the two pieces. But yes, I'd be open to an amendment. I do think it doesn't say that it shall include these pieces. So you absolutely could redact them if it wasn't going to be in compliance, because that is, kind of the number one thing on here is that all personally identifiable information shall be redacted. And this is just saying that it shall be limited to, but it doesn't say that it must include. But I would be open to it if you feel that it's not, that portion isn't clear enough.
Further? One more?
So, moving up in the legislation. So, on line 4, you have the department shall establish and maintain a tracking system, right, for all state complaints related to special education services. The tracking system shall include, but not be limited to, the following. And I want to skip down to G, status updates throughout the investigation process. So is the intention that every time something happens, the department has to update this with an update, or are you looking for weekly, monthly? It just,
So
it's
that
real vague. It's a shall include, but doesn't say how often.
So that tracking system isn't a public tracking system. That's for the department to track them. That's why it would include the complainant's contact information. That wouldn't be public information. Part 2 is what would be made publicly available. Part 1 is just, in order for the department really to be able to comply with Part 2, they'd have to do Part 1. But the Part 1 wouldn't be available because it has personal identifiable information. That's just the department keeping that.
Understood. May I clarify that? That wasn't my question. It's internal, but you're asking somebody in the department to do this work. Are you asking that every time there is an update, it's immediately updated, or are you looking for a monthly update, a weekly update? This is a big job.
So I'd leave that up to the department, however that can fit into. I don't want to overly prescribe to them, depending on what their workload is. I'd leave that. I think it's important to leave that up to them for how often they're able to update it. Thank you.
Abbas? Senator Abbas?
Thank you, Madam Chair. And thank you for taking my question. On line 11, and then again on line 29, it says you have to list the name of the law firm, a lawyer representing the school district. Would it make sense to make that for both sides? So perhaps if you don't want the family being contacted directly by someone, generally you want them to contact a legal counsel, if they have counsel.
Yeah, that piece could definitely be in there. A big portion of the parents tend to be pro se, so that's why it wasn't initially included in there. If you feel like that would be good information to have, I'd absolutely be open to having that information being included.
Thank you.
Any other questions, discussions? Seeing none, thank you very much.
Thank you.
Jay Siegelson?
Good morning, Chairman Ward and members of the Senate Education Committee. My name is Chase Eagleson. I'm the Policy and Planning Coordinator for the New Hampshire Council on Developmental Disabilities. We're a federally funded state agency mandated by the ADA. We have a couple of problems with this bill. One of them is something that Senator Altshuler addressed. In small school districts, this would be anything pretty much in here. I mean, even complaints could be personally identifiable information. If you have, one student in special ed, even up to 10, 20, if you have a complaint, people are gonna know who the student is. And with special education funding being such a tense issue right now, with school budgets being constricted, more harassment for families of special education students is not what we're looking for. On top of this, we're not actually sure the necessity of this, as was addressed in the House session or the House hearing. The department already tracks complaints and has just recently started posting them. I believe they said 3 or 4 months ago. So we're not exactly sure the necessity of this. Our most important thing to point out is that for small school districts, we don't want students having their PII put out there for a reason other than necessity. I'm happy to take any questions.
Okay. I have a question for you. What do you mean the bill is not needed at all?
What'd you say? I
Are
apologize.
you saying that this bill is not needed? We should not track complaints?
I believe that the department already tracks complaints, so I'm not sure on the necessity of this now.
Who is tracking the complaints?
I believe the Department of Education.
Okay, I will check with them. Any other questions from the members of the committee? Seeing none. Thank you very much. I see Diana Fenton is here, Attorney Fenton. She can answer that question. Thank you very much.
Good morning, members of the committee. Good morning. For the record, my name is Diana Fenton. I'm an attorney with the Department of Education. Here with me is Caitlin Giannotti. She is a Special Education Complaints Coordinator. We're happy to answer any technical questions as it pertains to House Bill 76. As an initial matter, the department does already track the complaints internally. We have our methods. We use an Excel spreadsheet. This bill before you would really codify or formalize the department's process. There are a few areas of concern we would like to identify for your consideration. I'll bring your attention on page 1 to line 18, which is paragraph 2. And the language is the summary of all state complaints. Currently, the department, when we have a written finding, a complaint, we will redact that and we will post it on our website. It's not a summary, it's the actual finding, it's the actual letter. Mm-hmm. And we have been going back in time and working on making sure that that is current and up to date. But it's not a summary. So that would be an additional task for the department. And we're not saying that we could not do that, but that is different than posting the actual investigative finding or letter. Also, for your consideration on line 19 on that same page, the time frame. Within 30 days of the issuance of the final decision on the complaint. While we appreciate and recognize the need for the department to be timely in producing our work product and making that transparent to the public, it's important to recognize that our administrative rules say that either side has within 20 days of the issuance of the complaint to file a request for reconsideration. So the 30-day time frame might run up into other considerations, such as I mentioned, the request for reconsideration. So that 30-day time frame, as a practical matter, simply might not be workable. No. Usually I'm loud enough without a microphone, so this is an impressive Tuesday for me. And finally, I will reiterate what the other speakers have raised as a concern on, again, same page, page 1, line 28. The name of the school district. It is the department's experience and our practice that if it is a larger district, such as Manchester or Nashua, will leave the name of the school district. But in large part, as has been testified to this morning, the majority of our districts that create New Hampshire are very small. And it is the department's concern that leaving in the name of the school district could lead to identifying the student or the family. We are happy to take any questions. I know there has been some discussion about the law firm. At this time, we don't currently track that. We certainly could, and we could certainly track it for both sides. I will agree with the testimony already given that typically the parents are pro se, but we could certainly put if they had an advocate or an attorney or something to that effect. Katie probably knows more than I do. We're happy to take any questions, but I will say this is Katie's first time testifying. I'm pretty tried and true, so this doesn't, I enjoy this part of the day, but we're just gonna take it nice and easy for Katie because I don't want this. She said, is it gonna be fun? And I said, absolutely. So I appreciate it. Thank you.
Thank you. Questions? Senator Altshuler.
Thank you. Two questions. Where is this tracking located currently on the DOA website? So, because I have not been able to figure that out. And then I have a follow-up question to that.
Sure.
The tracking is currently in an internal tracking system using an Excel spreadsheet that is shared between the departments of the Bureau of Special Education, including the governance, and the Department of Education staff have access to this tracking system.
Okay, so there's nothing available to the general public at the moment.
At the moment,
No information, right? Okay,
That's not entirely accurate.
okay,
The tracking system is internal.
right,
Most organizations have an internal tracking system.
Right.
I don't think that's unheard of or unusual. The department similarly has an internal tracking system. The complaint investigation letters, the findings, if you will, those are redacted and those are published on our website. And those you can find. And so we are working to go back in time so that we are up to date with those letters.
they are under appeals and mediation. It's a link right under where they post the redacted hearing officer decisions. And within that same webpage that has our redacted letters, we've also posted a fiscal year 2024 analysis of the special education complaints, and that is public for anyone to review. And they can it doesn't have specific district names, but it has trends.
your follow-up?
Follow-up?
Okay, so thank you for clarifying that. And so right now on your fiscal year 2024 special ed complaints, you are identifying like you mentioned, the larger school districts, like the Nashuas, the Manchesters, and so on and so forth. What is, and this is my concern, is that some of the districts are super, super small. And just by nature of there being a complaint and there only being a couple of kids who use services, you know exactly who we're talking about. So what's the threshold cutoff that you are using currently for size to determine whether to not redact that information or redact that information?
We we will take in consideration the size of the district. And within larger districts, we may leave like service delivery information. So this child has these services within an IEP, but within smaller districts, we're going to redact that, including specially identifiable disabilities. We may leave a general, the child was diagnosed with autism, but redact more pertinent, unique disabilities that would personally identify that specific child. So we do take measures to ensure the smaller districts are redacted kind of more efficiently than the larger districts to ensure compliance with that.
Okay. May I follow up?
Follow up?
Is there a number?
We do not have a number
There,
at this
like
time.
a student enrollment number, or that you differentiate between being a larger, smaller, medium district? Like, how do you Goldilocks that out?
It is
Case by case?
case by case.
Okay. Okay. Thank you.
Yes.
Senator Abbas?
Thank you, Madam Chair, and thank you for taking my question. I just want to make sure this, as written, is using the correct language. It uses the term respondent, but then it says the complainants. Is that normally referred to in your department as a petitioner, or is the complainants the correct term?
Are you referring on line 21 and? is it-
Line 8 and I suppose 21 as well.
We use the terms complainant for the filers.
All right, just double checking. And then I understand the issue with the summary of the allegations, how, you would be basically summarizing it for the public. Would it be any difference of opinion if it said, the subject matter of the allegations, like this is a complaint about this topic, and
I-
without getting into the details of what it is?
I tend to think of the hearing decision redactions on that. Right next to it, it says placement or evaluation, or it kind of has like exactly the subject topic rather than a couple sentence summary.
Thank you.
All set? I don't see any other questions. Thank you very much.
Thank you very much
Thank you.
for your time.
Anybody in the audience who wants to add anything to House Bill 76? If not, this concludes the hearing on House Bill 76. The next one is House Bill 208, relative to certification requirements for school nurses. And we have Representative Edwards, this crime sponsor. Somebody presenting it in his stead?
Thank you, Chairwoman Ward and members of the Senate Education. I'd be happy to introduce this as a courtesy for Rep. Edwards. Just- This bill is simply requiring that the school nurse be a registered nurse that's registered by the Board of Nursing instead of also having to be credentialed with the Board of Education. So there's a nursing shortage. This is trying to help clear up that shortage.
Okay. Any questions? Thank you very much. Pam, is it Maple?
Thank you. My name is Pam DiNapoli, and I am a registered nurse, and I'm a school nurse in the Manchester School District, and I'm here on behalf of the New Hampshire School Nurses Association. So I just wanted to start by really defining what a school nurse is, and then I want to take you through some history of this certification and then follow up with my own experience as a school nurse. So the New Hampshire Board of Nursing defines a school nurse as a school nurse should have a broad working knowledge of in-depth physical assessment and pathophysiology and should be able to function independently. A school nurse supports student learning by managing and advocating for child-adolescent health and safety in the educational environment. The school nurse promotes optimal health, wellness, and independence of individuals who within the school community. New Hampshire DOE Law RSA 229 states that a school nurse shall be a registered professional nurse in New Hampshire. The school nurse workplace is regulated by the New Hampshire Department of Education and the New Hampshire Board of Pharmacy, and the nurse is licensed by OPLC under RSA 326B. So in 1981, there was actually, the Department of Education actually approved certification of school nurses. They were included in the certification standards for educational personnel. So this lasted until about 1989. There was a lawsuit. There was some change in the Board of Nursing became OPLC, and there was some question about where the certification lies. So it kind of, the dust settled. There was no certification. So in Commissioner Virginia Berry started in 2009, and she served until 2017. So at the time, there was a school nurse coordinator, and the school nurse coordinator, together with Commissioner Barry, thought that we needed to set a minimum standard of practice as a school nurse through the DOE in response to the complexity and expertise that she saw was increasingly needed by the calls that the DOE was getting that they had to field related to the field of school nursing, and whether or not the school nurses who were being hired actually met a minimum standard. So what I just passed out to you is actually the minimum standard that they based these certification requirements on from the National Association. So at that time, they had a senator who was a former school nurse, and she introduced the bill, which was passed in 2016, 2017, and implemented in August 20th, 2016. Commissioner Barry retired in 2016. So after the bill was passed, there had to be rule writing. So a multidisciplinary group of us got together, worked with the sponsor, worked with the current commissioner, and at the time, the school nurse coordinator, and we wrote the rules, which were adopted in December 2017 and signed by the current commissioner. The rules recognized there needed to be different pathways to certification, leading to 3 different paths to certification. So when the bill was originally passed, there was step 1, step 2, and step 3. So in 2019, that was the first amendment to the original RSA. So from the time that Commissioner Barry left, the new commissioner came in, the school nurse coordinator left. So that left the implementation of these rules sort of in a little bit of chaos. So the School Nurses Association went to a rep who was also a retired nurse, and we asked her if she would introduce an amendment to the bill that would require a school nurse coordinator position. So that was passed. That position has never been filled by the current commissioner. In 2023, which was just last year, the RSA was again amended to remove the requirement for a BSN on hire. So step 1, the original bill sunsetted the requirement for a nurse to be hired as an ADN and then move through the steps. So that was repealed, and now you can hire a school nurse with an associate degree. And the argument there was there's a nursing shortage. We can't find BSN nurses. We need to open it up to ADN nurses. So that was passed. New Hampshire School Nurses Association worked with the author of that amendment, and we opposed the amendment, but we understood and actually said as long as the ADN nurse works towards a BSN, you can hire an ADN. Then this year, the RSA was amended again. We were contacted by Rep. Edwards this summer and said, could you help me work on an acceptable language that will decrease the barriers to hiring nurses? Because administrators are saying they can't find pediatric nurses. So we worked with Senator Edwards for the current language. So the language said acute or chronic, 3 years acute or chronic nursing experience with pediatric experience preferred. So in the House committee, the pediatric preference was a little confusing to them. They didn't know whether or not we wanted pediatric nurses or not pediatric nurses. But we said, you know, if they have a basic nursing knowledge, it's a good role for a lot of nurses. And so we went along with Representative Edwards' amendment. Then what happened when that was voted on in the House, there was introduced an amendment that repealed all the language in this bill. New Hampshire School Nurses Association wasn't aware that this amendment was going to be introduced, and there was no public hearing on the amendment. And up until now, we had been really receptive of working towards making this certification really accessible to all nurses. So we, as you're seeing the bill now, we would respectfully ask you to ITL it. Just some facts about certification. So according to the DOE website, there's 501 public schools in New Hampshire, and there are currently 457 certified school nurses. So that leaves less than 50 nurses who are not currently certified. You have to remember that this year was the first year that the ADN could apply for a school nurse job. So that number may include those new ADN nurses who have not yet begun the certification process. There's 14 other states in the country that require certification. Vermont is one of them. 35 states require a minimum of a BSN to be a school nurse. And an interesting story to me, but I got a call this summer from a nurse in Michigan who said that their state was trying to decrease the minimum standard from BSN to ADN, and had I ever heard of any other state doing that? So I was a little embarrassed to say we had just done that. So she was a little disheartened too. But so by these standards, you can see that the professional nurses are taking certification really seriously. School nurses are working nurses, so they really can't come and testify. But I think that the number of nurses who are certified really supports that they do support certification. But it's really not all about the numbers. What we really believe certification does is to provide for the health, safety, and wellness of the school-age children. So we would like to see, certification retained. We've heard arguments, so we've heard these three different amendments, and these are that we've heard that certification is a process that's hard and expensive. The standard for acute care hospital nurses is national certification, which is a much more rigorous and much more expensive process, and the acute care hospitals are not trying to repeal their certification for their nurses. We've heard a barrier to being a school nurse is being able to be hired at school because of the ADN requirement. This year, the standard was lower. We could hire ADN graduates, and there are currently only 7 vacancies of school nurses in the state. So it hasn't opened the floodgates for all of these nurses to come and be school nurses. There is a nursing shortage. So I would argue that a lot of the nursing shortage that these schools are seeing are with students who are in the special ed system who need one-to-one nurses, or students, so there's a student with an IEP or a 504, and within that IEP or 504, they need a nurse. That nurse is not a school nurse. That nurse is an acute care nurse, essentially taking care of a child in the schools. Those nurses don't need to be certified because they're not school nurses. So I think that a lot of the issue is really the hourly wage, because, for example, in Manchester, we had some openings that were easily filled by agency nurses. So the agency nurses get a higher hourly salary, but no benefits. So it's not that there are no nurses. There's an issue of nurses being hired based on the salaries that some of them are being offered, those school nurses who are not on the teacher's salary. So I'm a PhD prepared pediatric nurse. I worked at Children's Hospital in Philadelphia. I supervised a pediatric home care program. I taught pediatric nursing for 25 years. And in the role of the school nurse, I feel like I need to draw more on my competencies than in any other role. So, for example, if I have a child in the school who has diabetes, I have to manage that child in real time. If I took care of that child in the hospital, there's a whole team of people who are going to help me do that, including an endocrinologist, a diabetic educator, a whole series of medical orders. In the school, I see the child's blood sugar is dropping. I have to react to how I'm going to do that, knowing what's going on in the child's day. So it is a complex role. There's more and more kids coming that are sick. That's why there's more and more one-to-one nurses. And again, I encourage you to ITL the current version of this bill. Sorry I was too long on that one, but.
Always good to hear from an expert. Thank you very much. Questions? Senator Abbas.
Thank you, Madam Chair, and thank you for taking my question.
Yeah.
So just to clarify, the original bill that was filed, you would have been supportive of?
Yes.
And can I ask a follow-up?
Follow up.
I certainly appreciate wanting to have some minimum standards, especially some experience in the field before, just working exclusively with children. In a different area, there was a bill in judiciary where we allow paralegals to represent people in court. And I was a never, hard no, and I ended up supporting it because there wasn't any lawyers, at least enough of them. And they tried to do a volunteer lawyer of the day program, and they couldn't get lawyers to sign up for it. So I thought, well, I guess a paralegal is better than nothing. I suppose in the nursing field, if there's a lot of vacancies and hard to fill, wouldn't any nurse still be better than no nurse? So I guess I'm concerned about, if someone's shaking their head in that, I don't know the answer to that. I'm not taking this, I'm just saying, if they can't fill it, then how do we balance
I
that?
guess my argument would be they are filling it with the current standards. I think that it's kind of, do you want to put the health and wellness of your child in the hands of a paralegal, in way? Like you could have an LNA, an LPN, and an RN. So we're saying that we want an RN with an associate degree, which is a minimum standard. So this person is independent, autonomous. I think when we hear too about no school nurses, there are very few sub nurses. So if I have a nurse who's absent, it's not, like if a teacher's absent, there's sub problems with teachers, but I can put two classes together and I can teach that class. If the school nurse is absent, there's nobody to take that school nurse's place. So it has to fall on the administration. And I think one day for the administration to perform the school nurse's role is all they need to say, I want anybody else in this office because it's outside of my scope. So I think that, we need to focus on getting school nurse subs. I think we need to work on salaries. And I think that doing away with certification really is a solution looking for a problem.
Thank you.
Senator Altshuler.
Thank you, Madam Chair. Thank you for taking my question. So, if I understand the progression, we have lowered the standard so that currently someone with an associate degree in nursing who is also pursuing their bachelor's is able to work in the schools as a school nurse. Am I correct?
They have within 3 years to start a BSN program.
Okay. So they got a 3-year grace. And then they need to be enrolled in a program in order to maintain employment. Is that correct? Or maintain the certification as a school nurse?
Right. So they would come in as a stage 1, and so they would have within that. So now the current standard as an ADN comes in as a stage 1. They have 3 years to enroll in a bachelor's program.
Can I follow up, Madam Chair?
Follow up.
So as a person with a school nurse certification, managing a student body in a smaller school, for instance, I'm sorry, I shouldn't qualify that. Managing any school. You mentioned diabetes as being a challenge that has to be met. And some of the other challenges, for instance, it's my experience, but I'm going to defer to you. And I'm only drawing on my own experience from when my children were in school, that there were like 2 or 3 kids with 1 or 2 with diabetes, 2 with cystic fibrosis, one with a feeding tube. And this is just within a small middle school setting, and then a half a dozen kids with life-threatening allergies that all need to be managed on top of any emergencies that rise during the day. Can you tell us, other than managing a diabetic student, what are some of the other challenges that school nurses are facing?
Well, I would say right now the number 1 is mental health issues. The number of students that come in with anxiety and depression, and so they come in. People always say, "Oh, what do you just take care of tummy aches?" So the tummy ache is just the tip of the iceberg. Underneath that tip, there's a lot of issues that these children are facing. And so the school nurses are really struggling with how to manage the amount of anxiety and depression that they're seeing. and balancing. One of the important roles for the school nurse is to keep the child in the school. So how do we balance keeping the child in the school versus, is this an acute illness that has to go home? So in the winter, there's GI bugs going everywhere. So there's policies for that. But a kid comes in with a stomach ache, I have to decide, is this a GI issue? And really the standard that, you don't have a temperature, so I need for you to stay in school. But did I just make the stomach ache worse because that child's anxiety is so high that that's why they want to go home? So, we really have to balance that mental health complexity, I would say, is the number one. So that's the emotional. And then physical, you're right. Cystic fibrosis. When I first started to teach, I used to teach that you didn't live past 20 if you had cystic fibrosis. Now they live a long, healthy lifestyle. And it's because we've learned to manage it. And that includes managing it in schools. So you're right, feeding tubes, albuterol inhalers for kids who have severe asthma, tons of medication every day, the daily medications that have to be administered. So it's a whole spectrum of physical and emotional care.
Follow up?
Thank you very much for elaborating on that. So one of the things that we know statistically in the state of New Hampshire is that one in three children will experience some sort of sexual violence. And that disclosure may be to a trusted adult. So when you're talking about the student who comes in with the stomach ache that may be related to a GI issue, may be related to a fever, but also might be related to the very real possibility of being the victim of sexual abuse or harassment. And so is that also part of your job to identify those?
Yep. And I would say it's not only sexual violence, the amount of bullying that we see is also contributing to all those mental health issues. And I think that's why I use that whole iceberg analogy, is that they're not going to tell you the first time they come in why they have a stomach ache. They only know they have a stomach ache. So that trusted relationship has to be built over time before the child begins to disclose. And, I really hate that some nurses use the term frequent flyer, and they'll say, oh, he's just a frequent flyer. He comes in all the time with a stomach ache. There has to be a reason that they're coming in all that time for a stomach ache. It's not that they just love the office or you have mints that you're going to give them. I mean, there's some of those kids, but that most of them are coming in and there's something behind that stomach ache. So, the good thing in terms of the emotional is that there is a team of guidance counselors and social workers. So the nurse, if has a suspicion of frequent stomach aches and there's got to be another cause, they can consult their team and try to figure out who's going to be able to who has the best trusting relationship with this student.
Thank you. I have a question. So what you have described really tells me that it isn't just a couple of years in a nursing school and you come up with a degree. You have to have some experience, because again, with the stomach ache, with experience, you would take a look at it and see what else could it be, or what is my experience. So this young woman or man coming out of an AD program, how much experience do they have in pediatrics? How much experience do they have in clinical practice of young children?
Well, in the original bill before this current amendment, they would have 3 years of pediatric experience. The issue there is that the only pediatric experience you can really get in New Hampshire is at Dartmouth or at the Elliott, where they have inpatients. So you have to find your pediatric experience in clinics or as part of a home care job, or, it's really meeting the kids where they are. So that's why we went with Representative Edwards to say acute or chronic experience. So 3 years of experience. If you come in as a stage 1, so an ADN comes in as a 1, they have a year of mentoring. So they would have either a mentor from their district or they could reach out and we could find a mentor. We also encourage any nurse who has no school nurse experience. They may have 10 years of pediatric experience. And like I said, it's very different, some pediatric experience in acute care versus in a school. We encourage them, the New Hampshire School Association does a 2-day conference every August before the beginning of the school year called School Nurse Essentials. And we encourage any new nurses or any, experienced nurses to come to that conference so we can do trends, we can do legal issues, and we can really try to give them sort of that jump start before they start the role in the beginning of August.
Okay. Any other questions? Seeing no more questions,
All right, thank you.
thank you very much. Is there anybody else in here who would like to speak? Okay, just turn on the mic and let
Great.
us know who you are.
Okay, my name is Lori Collins. I'm the principal at Auburn Village School. And I was actually the one that spoke to Representative Edwards about my issues that I had hiring nurses. And so it came to this level. And I totally am on board with everything that Pam has said to you today. I'm shaking my head, yes. I think our issue is the way the credentialing is written. And I'll give you 2 or 3 examples of what I had to go through this summer. I finally found a nurse who was an emergency room nurse. She was a paramedic and she's a police officer. And she wanted to come work at our school. And the credentialing department told me I could not hire her. Because she didn't have pediatric experience. And I didn't have any applicants. I had this one person that actually wanted to come work for me. And I am the administrator that has to be in the office when I have no nurse. I have to administer medications. I have to worry about my diabetics because the safety of the school is on my shoulders. So I went to him and said, listen, I think the way this is written has to be cleaned up a little bit. Also, I was given an example of a retired doctor who wanted to, as a retirement job, wanted to become a school nurse. And they said, no, he could not get the credential. So there was a problem. So I went, Jess asked me, what are some of the issues you have at school? And I said, well, one of my biggest issues is hiring a school nurse. And again, everything that Pam said, I totally agree with. I think that maybe the way the wording is interpreted by some of the people in our Department of Education might be the issue, where it says for a school nurse 1, a registered nurse is defined by RSA 326B2 at the associate's degree level and have 3 years of clinical nursing experience, like she said, in pediatric nursing or and it says, or other related nursing areas, including but not limited to public health, community health, family mental health, emergency, and primary nursing care. So my thought on this is, because it's secondary, maybe if we could take a look at the bill. I agree with her on the credentialing piece. A nurse in my school does everything. But limiting them to a pediatric nursing is literally almost impossible to hire somebody with that kind of experience. Secondly, I would love to have a retired doctor at my school to be my school nurse. And if I can't even get a retired doctor so somehow we can work together to maybe work on some of this so that we can support our economic employment environment. Hiring teachers and hiring nurses is literally very strenuous for principals. We need to fill those spots. So I'm just urging that I'm not against credentialing school nurses. I just think that we may need to look at the requirements.
Okay. Questions? Senator Abbas?
Thank you, Madam Chair, and thank you for taking my question. were you supportive of the original draft versus the amended draft,
I'll be
or,
honest.
or none of the above?
None of the above. Again, I run a school, so I don't have a lot of time to reread the bills and all of that. I listen to Pam, and I totally agree with what she's saying. I just think it's an issue, and I kind of want to be a part of the fix.
Senator Altshuler.
Thank you. So, would it be helpful for your position if the person who I understand there is no doctor that has applied to be a school nurse at your school. It was a former paramedic, correct?
Yes.
Correct. So the former paramedic, if they were pursuing a bachelor's degree or had entered into that certification space, then would they now be able to take that position, or they're not? Okay, so I see. So with the current qualifications they have, there's no parallel to the associate's degree at all either. Is that correct? I'm trying to figure out.
Do you want to come up here so we can?
Yeah, we get it. It's so that people who are not here in the room can hear on the microphone.
So what Lori says is accurate. The way it's written now, the individuals who credential take it very literally. So they look for 3 years of pediatric experience. If they don't see that, you're not eligible to be credentialed. So the way that the Representative Edwards wrote is 3 years of acute or chronic nursing experience. So that would open it up to, we've heard the same thing, emergency room nurses. The issue that we have with credentialing a retired physician is that's not a nurse, so they couldn't be a school nurse. But if we can credential school nurses as a virtue of any of their experience, then that's what we worked with Representative Edwards on.
So Matt, may I follow up?
Follow up.
So that leads us back to the original language, correct?
Amended language this session.
Okay, not this floor amended language. What was amended in committee? Got it. Thank you. Thank you.
Thank you very much, both of you. Anybody else who wants to? Sean Thomas?
Thank you, Madam Chair, members of the committee. Sean Thomas with Demers, Praisall, and Thomas here today on behalf of the New Hampshire Nurses Association. And I won't belabor this. I really want to keep this sort of high level just to highlight some of what was just said. But I think, like Principal Collins said, how she agrees with Pam, I think we share her concerns as well. And I think what's important, and this has already been alluded to in your questions, but the bill as amended, the House version, is a far cry from what Representative Edwards had originally introduced. And that amendment obviously didn't have a public hearing. It represents a massive, massive change. I think what he was trying to accomplish was trying to introduce a little more flexibility, trying to ease the hiring process, but also maintaining that quality of care. And this goes in a completely different direction, what ultimately came out of the House. So again, a massive change. I think that warrants a little more work, at least some more time, and consistent with what Principal Collins said. I mean, I think the Nurses Association, the School Nurses Association, would be happy to work on those issues if that was the committee's desire.
Thank you. I think that probably anybody else who hasn't spoken, who wants to speak? I don't see anyone.
Thank you.
You very much. But this concludes the public hearing on the House bills that we've just heard. Thank you very much for coming. You can have that.
So the amendment was a committee amendment.